Who must perform the contract? The contract must be performed by the promissor, that is, the person who makes the promise. In general, the promissor is expected to perform the contract himself. However, in certain cases, the contract may also be performed by the agent of the promissor or by the legal representatives of the promissor in case of his death, provided the contract does not involve personal skill or confidence. Sometimes, performance by a third person is also allowed if it is accepted by the promissee. Thus, the law permits performance of a contract by different persons depending on the nature and terms of the contract. A contract must be performed by the promissor himself. In general, a contract must be performed by the promissor himself, because the promise is made by him and he is personally bound to fulfill it. When the contract involves personal skill, knowledge, or trust, only the promissor can perform it and no one else can take his place. For example, if a famous artist agrees to paint a picture, he must do it himself. Thus, the promissor himself is primarily responsible for the performance of the contract under the Indian Contract Act, 1872. The agent of the promissor. A contract may be performed by the agent of the promissor if the nature of the contract does not require personal performance by the promissor. When an agent acts within his authority, the performance done by the agent is treated as performance by the promissor himself. This is common in business contracts where routine or non-personal acts can be delegated. However, if the contract involves personal skill, confidence, or special qualification, it must be performed by the promissor personally and not by an agent. Thus, an agent can perform the contract on behalf of the promissor in suitable cases. The legal representatives, in case of death, unless personal skill is required, when the promissor dies, the contract may be performed by his legal representatives, provided the contract does not involve personal skill, personal qualifications, or personal confidence. The legal representatives are bound to perform the contract only to the extent of the property inherited by them. However, if the contract is of a personal nature, such as a contract to sing or paint, it comes to an end on the death of the promissor. Thus, legal representatives can perform a contract after the promissor's death unless personal performance is essential. A third person, if accepted by the promissee. A contract may also be performed by a third person if the promissee accepts such performance. When the promissee agrees to accept performance from a third person, the promissor is discharged from his liability. This rule applies when the nature of the contract does not require personal performance by the promissor. However, once the promissee accepts performance from a third person, he cannot later claim performance from the original promissor. Thus, acceptance by the promissee makes performance by a third person valid under the Indian Contract Act, 1872. Time and place of performance. The time and place of performance of a contract are important for the proper fulfillment of contractual obligations. If the contract specifies a particular time, the promissor must perform the contract at that time. If no time is mentioned, the contract must be performed within a reasonable time. Similarly, if the place of performance is fixed in the contract, the promissor must perform the contract at that place. If no place is specified, performance should be made at a place decided by the promissee or where performance can reasonably be carried out. Thus, performance must follow the agreed or reasonable time and place to be legally valid under the Indian Contract Act, 1872. If time is specified, performance must be done within that time. If no time is specified, performance must be done within a reasonable time. Performance must take place at the agreed place, or as directed by the promissee.